Supreme Court of Florida is now in session. The Honorable Chief Justice Charles T. Kennedy presiding.
Good morning and welcome to this session of the Florida Supreme Court. We have three cases on today's docket. The first case is the state of Florida versus Gabriel. Counsel for the petitioners recognized.
Thank you, Mr. Chief Justice. May it please the court, my name is Richard Pallas. I represent the state of Florida. In this case, on resentencing, the trial judge imposed a 15-year sentence on attempted robbery with a firearm, a second-degree felony, a 107.25-month sentence on aggravated assault with a firearm, a third-degree felony, and on resisting a law enforcement officer with violence, also a third-degree felony. All three of these sentences were to run consecutively to each other and an unrelated 10-year sentence on a prior burglary charge that he was currently serving. The Fifth District reversed this sentence because the 107.25-month sentences exceeded the statutory maximum on the two third-degree felonies. They also certified conflict with the Second District Court of Appeal in the case Champaign. And they also certified the same certified question of great public importance, which, to paraphrase, is the lowest permissible sentence as defined by and applied in section 921.0024, subsection 2. Is it an individual minimum sentence and not a collective minimum sentence when there is a single score sheet with multiple convictions? And the answer to that should be yes, based on both the plain language of the statute as well as this court's decisions in Butler and Moore. Regarding the plain language of the statute, it is clear and unambiguous that the Criminal Punishment Code conveys a clear and definite meaning that the lowest permissible sentence is an individual minimum sentence. If I may quote some portions of that particular statutory section. At the very beginning of subsection 2 of the relevant sentence, it says, the lowest permissible sentence is the minimum sentence that the trial court may impose absent reasons, a valid reason for departure. Going now to the actual permissible range, it states that the total sentence points shall be calculated only as a means of determining the lowest permissible sentence. The permissible range for sentencing shall be the lowest permissible sentence up to and including the statutory maximum as defined in section 775.082 for the primary offense and any additional offenses before the court for sentencing. Now going to what will be known as the lowest permissible sentence exception portion of this, it states, if the lowest permissible sentence under the code exceeds the statutory maximum sentence as provided in section 775.082, the sentence required by the code must be imposed. In this section, it does not contain the language from the section pertaining to the permissible range. It is not referring to the primary and additional offenses. Instead of stating the statutory maximum as defined by the section with the statutory maximums for those multiple offenses, it just states the statutory maximum sentence as provided in 775.082. Now, to say that that means it refers to the individual sentence, that's very consistent with what this court held in Butler. In Butler, while that only referred to one felony count, the court clearly held that when the lowest permissible sentence exceeds the statutory maximum, the lowest permissible sentence becomes the maximum sentence, which the trial court can impose. Later, this court also held in Moore that under the Criminal Punishment Code, together individual sentences only establish the minimum sentence that may be imposed. A single maximum sentence is not established. Each individual offense has its own maximum sentence, mainly the statutory maximum. Now, Moore necessarily wasn't referring to defining the lowest permissible sentence at this time. This was just to say that Tripp v. State and all of its progeny were only applicable to sentences that were imposed under the prior sentencing guidelines, not the current criminal punishment code. It appears that any ambiguity that's being cited to this statute, it's not in the statute itself. The lower court decisions appear to take more issue with this language and more, in saying that the floor is still a collective, but the ceiling is not. It doesn't go with common sense that we would still have one collective and then we would have everything else have a separate statutory maximum sentence. Further, this court's language and more saying the lowest permissible sentence becomes the new maximum. And this court's, that was the court's language in Butler. And then the court's language and more saying that there is a maximum for each sentence. If the lowest permissible sentence becomes the new maximum, the maximum clearly is the lowest permissible sentence, which should be for each individual sentence that we have. Now, I note that in our reply brief, we addressed that the staff analysis as addressed by defendant talks about how it could be read in a way that they wanted a collective floor. First, that language in the staff analysis is irrelevant because the plain language controls and the plain language supports the state's position that it's an individual sentence. But it's also meaningless. It's been held in the United States, it's been said in the United States Supreme Court and in this court that staff analyses are neither compatible with the court's judicial responsibility of assuring a reasonable, a consistent, effective application of the statutes, nor conducive of the genuine effectuation of legislative intent. And going into this state's hypotheticals, if in the state's first hypothetical, in its initial brief, if we are to take the defendant's position, we don't have guidance in the statute as to how that should be. It's not written in there that in our first hypothetical of 2 third-degree felonies with a statutory maximum of 10 years together, but with the lowest permissible sentence of 60.1 months, there's no guidance in there to say, we'll put 60 months on the first of the third-degree felonies and then consecutively sentence on the other one to 0.1 years. That is guidance that the trial courts are going to struggle to apply consistently. And going into this, to the state's hypothetical in its reply brief, where we have multiple felonies, 10 third-degree felonies, statutory maximum of 50 years, we're now looking at the anywhere from, let's say, 60.1 as well, or even, let's say, 75 for a little more consistent of a number. In that case, do we sentence the first of the count of those 10 counts to 60 months and then 15 months for all the consecutive counts? But then count 1 is reversed either on appeal or by some collateral method. Are we then to resentence them to get the trial court's original intent on those 15-month sentences, or are we violating double jeopardy principles?
So what do you make of Mr. Gilbert's argument that the score sheet that we're using is in some ways a collective score sheet? That is, it takes into consideration not just the primary offense, but the additional offenses. And that it stands to reason, intuiting from the fact that it's an integrated score sheet, that we should read the whole text of the statute to make it collective in application. What do you make of that argument?
Well, yes, Your Honor. It's true that these points are totaled together with the primary offense, the additional offenses, also prior acts and other potential points that can be assessed either by victim injury or legal status. While these points are collected together, we still don't give general sentences in this state. And the language still of the lowest permissible sentence section, coupled with the permissible range, it's far clearer to the state that this is an individual sentence because we impose sentence on each and every count.
So we should, you're asking the court then to read the words lowest permissible sentence actually as lowest permissible sentences. Is that right?
That is correct, Your Honor. Here, of course, the language specifically stating the lowest permissible sentence, but by saying there are multiple sentences, we have lowest permissible sentences, and we have multiple statutory maximums for each one of these felonies as defined in section 775.082. If this court has no other questions, I will rely on my briefs. And I ask that you approve the second district's reasoning in Champaign and reverse the fifth district's decision with directions to affirm the trial court's sentences.
Before
Thank
you take a seat, I do have one. If you could walk me through some of this language in 921-00242, the total sentencing points in the middle of subparagraph 2 shall be calculated only as a means of determining the lowest permissible sentence. So that is saying that we combine all sentencing points for all offenses. You agree with that, right?
Yes, Your Honor.
And it uses singular, the lowest permissible sentence. And then we have the next sentence. The permissible range for sentencing shall be the lowest permissible sentence up to and including the statutory max as defined in 775.082 for the primary offense and any additional offenses. So that sentence would seem to say to me, and I'm wondering what I'm missing, that whatever that number is from the combined total, that gives you a sentence, a minimum sentence that applies to all of the offenses, both the primary and the additional, which is contrary to your argument, correct?
Well, yes, Your Honor. I can see that reading it in that way would be contrary to what the state is saying.
And then the next sentence says the sentencing court may impose such sentences concurrently or consecutively. So we're talking about a minimum sentence that's calculated from all of the sentencing points from each of the convictions. And then those sentences are going to be either run consecutively, concurrently. Doesn't that also make clear that all the points are used to determine a minimum sentence for each individual conviction that's being sentenced?
Well, the way that the state reads that, Your Honor, is that we're just calculating the lowest permissible sentence for each of these sentences. Mm-hmm. We're clarifying in the language, the court may impose these sentences concurrently or consecutively by saying there's only going to be one lowest permissible sentence. We don't use separate score sheets.
And that the score is used to determine an overall sentence, in which case it would need to talk about an overall sentence instead of sentences that could be run consecutive or concurrently, because we're talking about the sentence that is derived using the formula to get the lowest permissible sentence for the primary offense and any additional offenses. So I'm just having a hard time struggling to see where you get an argument that's consistent with that language and leads to the result that you're seeking.
Well, the reason being is because after defining what the permissible range is, it qualifies it with the language of a primary offense and additional offenses, whether one or many more. The fact that we then get to the lowest permissible sentence section, and we're only referring to the statutory maximum sentence without mentioning a primary offense, additional offenses, we're not saying all of the offenses. That is why the state reads these sections in that way, Your Honor. Thank you. If there are no other questions, I ask that you reverse the Fifth District's decision with directions to affirm the trial court sentences.
All right. Thank you. Counsel for the respondent is recognized.
Good morning, Mr. Chief Justice, and may it please the court. My name is Scott Hubbard on behalf of the respondent, Mr. Ridge Gabriel. Today, my time, I'd like to convey 2 points. The first point is that the language of the statute at issue 921-0024 subsection 2 is not clear. And given that it is not clear, I believe that applying the canons of statutory construction, the conclusion as identified in the Fifth District Court of Appeal below is that the lowest permissible sentence is a collective minimum sentence to be applied to all available or to all offenses before the court for sentencing. And They are not an individual sentence. Having said that, the language was discussed. The sentence there it says that if the lowest permissible sentence under the code exceeds the statutory maximum sentence as defined in 775-082, the sentence required by the code must be imposed. The language, whether it applies to the primary offense only or primary or additional offenses or primary and additional offenses together, it's just not there. It's silent as to that issue. There's just a lack of clarity there on what it applies to. That the other sentence there talking about the range, that the permissible range for sentencing is the LPS up to the statutory maximum for the primary offense and any additional offenses before the court for sentencing. I submit that we should apply the word "and" in the conjunctive sense as it relates to the range that is created. It's the LPS, which is a collective endeavor. As was mentioned, it considers the primary offense, the additional offenses,
Mr.
prior
Hunt,
record.
can I take you to more for a second? Does it help or hurt you?
I believe more is helpful to us because it for two reasons. The first is it discusses the transition from the prior sentencing guidelines to the criminal punishment code. And it conveys the idea that the part of the purpose of enacting the criminal punishment code was to increase or return rather discretion to the sentencing courts that wasn't there under the guidelines. And it talks about the LPS is the floor that exists there for the sentences, but each individual offense has a statutory maximum, and the court is free to sentence that individual up to the statutory maximum for any offense, and then their total sentence must at least meet that LPS. So I believe more conveys the exact understanding of what the legislature intended in passing and adopting this criminal punishment code.
Counsel, I'm sorry, go ahead, Justice Correal.
No, go ahead, Chief.
Let me take you back to the text of subsection 2. Now, it says there that the lowest permissible sentence, the permissible range or sentence shall be the lowest permissible sentence up to and including the statutory maximum for the primary offense and any additional offenses before the court for sentencing. Okay, so it's talking about that permissible range that applies to the primary offense and additional offense. Now you say that's rolling those together. Where I get tripped up in that argument is the next sentence, which says the court may impose such sentences concurrently or consecutively. I'm struggling with understanding how, if that's all rolled up into one such sentence, which is it's referring to the lowest permissible sentence, it seems like, how that can be reconciled with consecutive sentencing. I may be missing something, but help me understand how the way that is structured fits the structure of your argument.
Well, to that, I would say that the concept is whether you have one offense before the court for sentencing or many offenses before the court for sentencing, each offense will be given an individual sentence, and the lowest permissible sentence is compared to the sentences received in the aggregate for each individual.
Well, I understand
sentence.
that's your argument, but what I'm struggling with is how to reconcile it with that text, because it talks about that permissible range and the lowest permissible sentence for the primary offense and any additional offenses, and then it's talking about those in the very next sentence as separate things. So I understand that your argument about this. I mean, it seems to me that the whole argument here is about this collective statutory maximum. That's kind of a central concept in your argument, correct?
Yes.
I'm just having trouble finding that in the text. I understand you're kind of back into it, but it seems to me the most natural reading does not fit that concept.
Sure. Two things there. I think
Before
the
you
first
answer,
one.
Mr. Hubbard, if I could clarify, and I apologize to Mr. Pallas, it seems that, well, my notes from all my oral argument preparation disappeared from my iPad this morning, so I was sort of scrambling and came up with the questions that I had, but delivered them to the wrong party. So Justice Kennedy is asking the questions to you that I actually intended to ask to you, and he's done it more articulately and to the right party. So.
To answer your question, Justice, Mr. Chief Justice,
Counsel, we're having trouble hearing you, or at least I'm having trouble hearing.
I'm sorry. I'll try and speak louder. Can you hear me now?
Sure, that's fine. Yeah.
Okay. With that, the next sentence there, discussing imposing sentences concurrently or consecutively, I argue that again is a transition away from the sentencing guidelines and allowing further discretion by the sentencing courts to sentence a defendant consecutively or concurrently if the court finds it's appropriate for a longer sentence. If you look to the rest of Chapter 921, it will discuss that the 921-002-1C, the penalty imposed commensurate with the severity of the primary offense and the circumstances surrounding the primary offense. The severity of the sentence, this is D, the severity of the sentence increases with the length and nature of the offender's prior record, and on it goes as it defines terms and it lays out the framework that, you know, it's concerned with the overall offenses that are before the court, and it's providing discretion to the court if it finds it appropriate to sentence the defendant to consecutive sentences. And that's a transition away from the prior sentencing guidelines and an effort by the legislature to return discretion to the sentencing courts. Now, if I may briefly...
I understand that about the moving away from the sentencing guidelines, but there are very important elements of this that are designed to limit judicial discretion. Wouldn't you agree? Isn't the lowest permissible sentence is specifically an effort to limit judicial discretion? Not that it's an absolute requirement, but it creates a constraint on judicial discretion. Isn't that correct?
I agree with that, and there are constraints, and the notion is that this it wasn't a return to prior to 1983, where courts had unfettered discretion from a fine up to the statutory maximum, and that's reflective of an effort by the legislature to impose sentences for defendants that were in some cases receiving sentences that were light, or as part of the CPC, they removed some of the parole considerations and some of the administrative release. Those were all, to an extent eliminated. And the reason was that they wanted to punish offenders for the circumstances surrounding their offense or offenses, but they also wanted to return discretion to the courts if they determined that a more severe sanction was appropriate than would have been the case under the guidelines. And
let me go back to the portion of the text I was talking about and go to the next sentence, because that seems to further reinforce that we're talking about the lowest permissible sentence that is applicable to each individual offense, and for which the court can impose a sentence that's either consecutive or concurrent. Because it goes on there and if the lowest permissible sentence under the code exceeds the statutory maximum, the sentence required by the code must be imposed. So it keeps talking about these as individual sentences, and that's all interspersed with this the references to the lowest permissible sentence.
Sure. So with that, I would say it appears clear to me that the LPS is a cumulative endeavor, again, taking in all of those relevant factors. There's the 9 categories.
Well, what I'm struggling to find is some source of that clarity, because it's your position, it's really ambiguous. So but if to the extent that you just said that it's clear to you, I'm trying to find what gives you that clarity in the text of the statute, because I'm finding clarity that points in the opposite direction, to the opposite conclusion.
Well, to that extent, I argue that the language itself isn't clear, and it doesn't set out one way or the other. And that because it's not clear, I submit that that this court should look into the canons of statutory construction. And part of that is looking into the evil to be corrected and why the legislature chose to go away from the sentencing guidelines and enact the criminal punishment code. And part of that.
Counsel, I hear you. That sounds like an argument from legislative intent. What canon of statutory construction gets you to where you want to go?
The canon, well, the evil to be corrected, the first of all, looking at the legislative history, looking through to giving effect to the legislative intent.
Those are all questions about the purpose or the intent here. My question, I think the Chief's too, is how do you read the two sentences that we've focused on, which refer to individual maximums, for example, and come to the result that, in fact, the legislature meant here that this was a cumulative project? Can you help me with an actual canon of interpretation from the text that gets you to where you want to go?
An actual canon from the text?
Like, for example, could you make an argument from the whole text canon about reading this together? Or does a reading of the whole text ultimately come down on the state side? I mean, without recourse to arguments about legislative intent, can you use some canons of statutory interpretation to square these sentences that talk about maximums individually with your result or not?
So yes, it read in isolation, the text is ambiguous, and that's getting into the statutory construction canons. If reading it in pure materia with the rest of Chapter 921, and I would also like to point out Section 924.06 that was passed at the same time with the same bill as the Criminal Punishment Code that allows a defendant to appeal a sentence which exceeds the statutory maximum or the consecutive statutory maximums. And so I think that language is important because it shows that in taking in context together, you have the statute that talks about 921.0024 that says where the LPS exceeds the statutory maximum, the sentence by the code must be imposed, with 924.06 that says that a defendant may be able to appeal. You get to a point reading in peri materia that as a whole, this sentencing framework was designed to, again, increase the court's discretion in sentencing and create a range that was a different set of ranges than what was under the guidelines.
Counsel, I'm sorry to interrupt you, but I'm having a hard time, having listened to what you've said and the answers to the questions. I'm still not completely clear on what you're saying is the source of the ambiguity in the language that we've been focusing on. So could you just articulate that as precisely as possible?
Yes, in the statute 921.00242, the sentence that says, if the lowest permissible sentence under the code exceeds the statutory maximum as provided in 775, the sentence required by the code must be imposed. That does not address either primary offense, nor additional offense, nor in a collective sense. And that language is unclear because it's silent to the issue and it doesn't address it. The previous sentence that talks about the range doesn't provide any further clarity because it says that it's using, I argue that it's more toward a collective because it says primary offense and any additional offenses.
So can I ask you about that? So if it said for the primary offense and for any additional offenses before the court for sentencing, would that resolve the ambiguity?
There could be several ways that the legislature could have phrased the language.
But let me just ask you that. I mean, is that the issue? Because my understanding is that just as a matter of basic grammar, that it's appropriate to use for to be linked with both the primary offense and the any additional offenses, that there isn't in terms of just grammar and conveying meaning, that you aren't required to repeat the preposition in that situation. I mean, is that what it comes down to?
What it comes down to, I argue, is that the word "and" there is used in its conjunctive sense, and that it's for the primary and additional offenses, not
Right.
or
Okay,
the additional
so hold on.
offenses.
So I just want to be clear about that. So if it said for the primary offense and for any additional offenses before the court for sentencing, would that take away the ambiguity that you're relying on?
It goes toward that. It becomes clearer. I think if the legislature had said either instead of and, or as well as, or any other word besides and, I think you can get to a point where it's recognizing that the range is an individual range, as opposed to what the LPS is, which is just a guideline that must be enforced, but it's a guideline that the sentences received on an individual, overall, whether it's one offense or many, the sentences must meet that LPS. And it can be met in any number of ways up to the trial court's discretion in its determination on what it feels a sentence is appropriate. And if I may, in the brief time that I have left, I'd like to discuss, if the state's proposed interpretation is adopted here, I think that there will be several negative consequences in addition to the restraint of judicial discretion. This is talked about in other cases, particularly Champaign talks about it. There may be, of course, this wasn't briefed, I believe that there could possibly be Apprendi issues by having a sentence that must be imposed without a finding by the jury. In addition, there might be due process issues that come up with this double jeopardy. I know specifically in Cologne, they talk about jail credit issues that are involved because someone sentenced globally has, a time frame in the DOC and they don't get the appropriate jail credit. And there are just a multitude of issues that will come up if the state's interpretation is affirmed. However, if the 5th District Court of Appeals decision below is affirmed, what remains is the legislative intent and the way that sentencing has gone in Florida since the CPC was passed, and that's that the courts have discretion to sentence a defendant as it determines is appropriate, bounded by the lowest permissible sentence. It cannot go below that with absent a valid reason for departure, and upwardly bounded by the statutory maximum. I think that the language in Moore points to that. Again, talking about the transition away from the guidelines and why the sentences are no longer interrelated.
Yeah, Counsel, I don't really understand how the interpretation advanced by the state is substantially limits the discretion of the sentencing court. For one thing, the sentencing court can always run these sentences consecutive, can always run them concurrently. And so if it's run concurrently, I'm just at a loss why that would, since that discretion is there without any question. And it seems to be that's a very significant thing, and it fundamentally undermines your argument about discretion.
Well, the point about discretion there is that, as the section says, that it must be imposed. There's no discretion for a court to sentence anywhere below that. For example, in this case,
if it's got to be imposed for one of the sentences, in the circumstances where it would have to be imposed for one of the sentences, but not the others, in your view, if the court just, and in the state's view, it would have to be imposed for all of them. It just seems like the issue is resolved. If the court wants to be lenient, the court can impose those sentences concurrently as opposed to consecutively. Maybe I'm missing something.
Just briefly in this case, I'll say that For instance, if the court determined that an incarcerative portion of the sentence was appropriate, but also wanted to have consecutive to the incarcerative portion be probation, it wouldn't be able to because the LPS was 8.93 years. It has to meet that before it gets, to a probationary period. It cannot do that because it must impose that, and it has no discretion to go above or below because it, under that interpretation, exceeds the LPS. Now, the court, under what I argue is the incorrect interpretation, was able to sentence him from the 8.93 years to 25 years if it felt that some sentence of 15 years and 10 years of probation, it would be able to fashion that in a composite sentence. And
all right, Counsel, could you sum up very quickly? You've gone overtime with a lot of help from me.
I apologize. I thank you for the extra time here. I will briefly say that our prayer for relief here is that this court upholds the decision in the 5th District Court of Appeal that the LPS is a collective maximum, and it must be imposed only when it exceeds the maximum of all offenses before the court for sentencing. In this case, it was not, and the trial court was incorrect, and I ask for an affirmance of the 5th District's decision.
All right, thank you. Rebuttal from the state.
Thank you, Mr. Chief Justice. The state has 3 short points on it of rebuttal. First, the state reiterates that this language is clear and unambiguous, but if we did resort to canons of statutory construction, I believe the in peri materia, or viewing of the whole text, still supports our interpretation. While only briefly mentioned in our initial brief, the doctrine of express inclusion and implied exclusion would also support that if this court determined that the language was unclear or was ambiguous. Further, this court recently mentioned in one of its prior opinions in Thompson, mentioning the use of the variation of material terms canon, which again, as the state has mentioned that in the permissible range, they mention after statutory maximum as defined in section 775.082 for the primary offense and the additional offenses, that is lacked when we're referring to the lowest permissible sentence itself in the next section. Thus could be considered a variable, but that was not briefed, and the state would be willing to perform supplemental briefing if requested by this court. Getting to the state's second point on rebuttal, again, this statute is not ambiguous. The source of ambiguity is only in the lower court's interpretations of Moore, which can be clarified by this court. In fact, the 5th District in Gabriel took a lot of credence from, I believe, Judge Warner's dissent in the case Dinar, which that case she actually ended the dissent in there stating that while her interpretation supports it being a collective statutory maximum, that runs afoul of Butler, and it should only be instead for the primary offense rather than the full permissible range as defined by the primary offense plus the other additional offenses. And for the state's third point, Apprendi and due process, while not briefed, forgive me for not being able to more artfully address these, but it has been held that Apprendi, its progeny of Blakely and Elaine, are not affected when habitual felony offender sentences are given, prison releasee reoffender sentences, everything involving the statutory maximum growing based on conduct that is allowed in other portions of our sentencing statutes, as what happens here in subsection 2 of section 921.0024.
Counsel, can I just ask you kind of a practical question? Do you think that some of the confusion lies in the structure of the score sheet itself, and that it only asks for a statutory maximum in one line, which seems to combine the totals?
Yes, Your Honor, I could see some confusion where it first starts on most score sheets with the statutory maximum, then we show the lowest permissible sentence, and then the calculation is made and the judge records what sentence. If this court could always amend its own rules to change the layout of the score sheets if it would like, but overall, while that may contribute to some ambiguity, the state still asserts that the statute itself is not ambiguous. And as long as we guide ourselves by the statute, we come to the proper conclusion that it's an individual sentence. If there are no other questions, Your Honors, I request that you approve the decision in the 2nd District in Champaign and reverse the 5th District's decision in this case with remanding with directions to affirm the sentences. Thank you.
Well, thank you, counsel. We thank both of you for your arguments in this case today. And the court will now prepare to take up our second case in a moment.